much for the invitation, and I'm happy to participate. I wasn't aware of this very interesting work that has been ongoing for some time, and I think it's a very good idea to look at the specifics of the costs of non-Europe and the potential, and to do that in a sustained empirical manner. So I have taken my lead in terms of what I could add to the debate, the subtitle indeed, the untapped potential, or in other words, what is the sort of the European added value? What can we think of in terms not only from sort of the alternative, the scenario of gloom and doom, but what, from my perspective, standing outside of it from a more broader constitutional perspective, what would be good. So indeed, I actually thought I would focus my remarks on three things, three different topics, and it's not that I'm putting them in for debate. I think that is also the idea, that there is a dialogue. It's not that I have a definitive opinion already. On some of them I do, but not on all of them. Anyway, the three topics that I thought I would put in the mix, and that are not, the first one is not, is in the summary that was done, but the written summary rather than Wouter's presentation today, and that's on the role of differentiation in this area, but also inevitably more broadly within the European Union, and inevitably that brings in something also on Brexit and that scenario that is facing the European Union as a whole. I think it's relevant to say something on that. The second, and this kind of runs through also the report, I want to say something on obviously agencies are important here, but also the databases and the principle of interoperability, and certain assumptions that are made also in the report as to possible untapped potential. So I want to look at that also from a more general perspective of rule of law and protection of fundamental rights. And finally, if we get to it, I'd like to say something on accountability. I don't know how long you'd like me to talk for, Gabby, as a maximum. I haven't actually.
Around about 12 minutes.
12 minutes. All right, well, give me a warning when I'm running out of time.
So.
Okay, fine, if I do. So the first topic of differentiation, I think this is in the report and also in the summary, and there's mention made of the temporary workouts for various member states and how that is affecting the operation of Schengen, and whether and border controls, and whether there is obviously behind that is also the assumption that this should not be made permanent, but should rather be limited in time, and indeed certain of the moves that are ongoing at the moment go in that direction. Of course, the worst case scenario is that Schengen would collapse completely, or indeed the EU would collapse. That's the I was reading, in fact only today, there's been a German military study apparently that holds out that the collapse of the EU is a conceivable worst case scenario in terms of future developments. It's not saying that it will happen, but that it is a conceivable one. Obviously that's one that nobody wants, but not even the collapse of Schengen. So do we, in fact, I think this is something that needs to be debated, is in terms of potentially untapped potential, or at least we must view this topic within the more general panorama of the future of the European Union and the discussions on the need for more flexibility and more differentiation as, in fact, almost counterintuitively keeping it all together. Of course, this isn't unknown in the history of the European Union or indeed of this area. There have been a whole series of, you might say, bespoke arrangements for individual member states, most notably for the UK, which had a whole series of them, both opting out and then opting back in. But also, for example, for a country such as Denmark, and if you look at also what happened earlier this year, after a referendum in Denmark where there was a very specific arrangement made in terms of its future participation in Europol and the databases of Europol, despite there being a negative referendum result. So I think this is something that needs to be factored into the debate. I am not saying I'm not arguing in favour per se of more flexibility, but I think that the reality is there, and that's something that we need to engage with also, perhaps more proactively and specifically than has been done to date. What are the parameters in that regard in terms of flexibility? And I just saw that there's been an interesting new report, I think it was just published in the past few days, on relaunching the European Union by SEPS in Brussels, where in fact it's discussed, and I think it's an interesting discussion on the and it goes in a different direction, the possibility of suspending member states who don't control the borders in an adequate manner for the possibility to exist, to be suspended from Schengen or readmitted. Now, obviously, that goes very far. It would clearly require treaty amendment and a lot more guarantees to be put in place. But I think these are scenarios that are out there, so I don't think that we can just think simplistically in terms of ending all derogations or that kind of thing. I think more is at stake here. But the main thing that I really, so that's for what it's worth, I wanted to say something about that and put it in a broader perspective. But when we look at internal and external borders, but also indeed at counter-terrorism and the security union, which is also very well developed in the work that has been done by the European Parliament, one of the key things that comes through is and indeed in the SEPS report as well, they stress that that obviously in this area, perhaps in this area in particular, the EU needs access to good data, so that the data that are required in the various areas for managing migration, for asylum seekers, for all of that, for countering terrorism and catching terrorists in certain crucial situations, is of course vital. And there are quite a number of agencies, also new agencies, but also databases in existence. And the principle of interoperability is one of the key principles that is stressed over and over again, and I think is being implemented partially in practice, also in terms of agreements between different agencies. But also there are huge problems there, and clearly these are issues that need to be addressed. But I would just also say, so there is a potential, and that's pointed out in the report, for improvement of the way in which law enforcement, but also those implementing border controls, either at the external border or internally, the way in which they exchange data, that can be improved from a technical point of view and also from a legal and political point of view. But the problem is there is also, and I think this is something where I would see there is an untapped potential to look at the costs for individual in terms of the creation at the European level of what I would describe as systems of invisible information sharing, not alone among the actors at the European level, but also crucially with law enforcement and other actors at the national level. Now, that may be necessary and desirable in terms of certain objectives, but I think the problem is that there aren't enough controls in place as to how that is actually implemented. So I think there is a need for more supervision, more specific supervision, not just over individual agencies and individual databases, but about the connections between those agencies and those databases, both at the European level and with the national level. Because as we know, the European Union, of course, is not just a supranational system, but it's also not just an intergovernmental system. And you see that in this area, it is really about the administration of, if you like, across borders, so a more composite system that is composed both of the European level and the national level. And you see that, I think, very, very clearly in this area in particular. And one of the major issues is that from the perspective of the individuals affected by this kind of cooperation is that they have no idea what information has been retained on them, nor how it is being accessed by national authorities or European authorities, or to what extent it is part of or it is factored into whatever decisions are taken in their regard. So in this area in particular, I think it is very difficult for individuals, for there to be talk of access to justice for individuals, a right to data or to control the data or the use of data. I think that is something that also will not be changed by the new data protection package. And I think this is something that needs specific and further attention. So that was my second point on just highlighting the fact that, in fact, from a legality point of view, it's very difficult to remedy that situation either through the courts or, I believe, through parliaments, because I don't think that the parliament, there can be, of course, a certain amount of accountability, and that's very important for individual agencies, and there can be cooperation between national parliaments and the European Parliament, and that's very good, but I don't think that that is actually adapted to the nature of this kind of information sharing that is going on and will undoubtedly increase in the coming years. So I think there is a moment to reflect more horizontally on the growth of these issues, and to perhaps think more horizontally of supervisory mechanisms that can apply across the systems. It's not an easy challenge, but I think we can't just keep on adding to it as we're doing at the moment. And I think there was some discussion at one point, or was it in the, it was in the SEPS report, that we need a single agency that brings all the databases together. And of course, that we already have a new agency, the EU LISA agency, that could potentially function in that regard. But I think the debate is more complicated than just adding agencies and melding that all together. So, in that connection, and there's some overlap now already with my third point. In that connection, I think and I would come back again to Brexit, because obviously the cost of saying to the UK that they can't keep their existing opt-ins in certain specific regards, whether that's the European arrest warrant or whether it's access to Europol databases. I think the cost for the rest of the EU is considerable. The UK is actually very active in these areas in terms of the provision of information and its use of, for example, Europol, also its participation in all kinds of joint investigation teams and other practices. So to simply say that the UK be totally treated as a third country, there will be a cost involved from the point of view of security for the rest of the EU. On the other hand, obviously, it needs to be looked at very careful. I think what the UK itself is proposing, if you look at its policy papers in this specific regard, is that basically it can just continue cooperating more or less as it is at the moment as a full member state, in terms of access to Europol, access to Europol databases, and in other regards. Now, there is some sort of a precedent with Denmark. Denmark is in the although it's the opposite. Denmark is in the extraordinary position of being a member state, but for the purposes of access to Europol databases, is specifically a special kind of third country. So, there are precedents within the European Union for also enabling former or even existing member states to participate in particular ways. But I think this is something that needs to be looked at very carefully, also from a rule of law and a data protection perspective, and also the issue that won't go away, who is the judge in the event of a dispute, if it does come to that, although it's difficult to see how actual concrete cases can be brought in these areas. The difference with Denmark, of course, is that the jurisdiction of the Court of Justice fully applies. So basically, I think I probably said pretty much what I have to say, Gabby.
Perfect. Thank you very much, Deirdre. Actually, what you pointed at in terms of differentiation and the second point are 2 points that, also from my point of view, if you look at the area, are crucial ones, because the one that you said, that you elaborated on with the data protection and the sharing of data, is touching upon the basic fabric of what we work with in the area and what we can work with. And unless we solve that and we have access to the data in a way that adheres to our principles of legality and transparency, the further development of the untapped potential will be difficult, most of all. And what comes second with the differentiation is something that indeed we need to focus on in the future. I think it will be interesting to discuss how new structures must be shaped, should be shaped, if there is precedence or not. But indeed, I hope that this will come up in the discussion, because these are the 2 points, and with me especially the data point is something that I think needs to be elaborated further on. Thank you very much, Deirdre, for now.
Can I just say one thing
Absolutely.
on that, because I don't want to. I'm not arguing, that individuals have to have access to their data. I think we also have to. Some of it will be highly classified data. We're dealing with intelligence, but we're not only dealing with intelligence, we're also dealing with law enforcement. So these are tricky areas, but I didn't want to go off on a tangent, but I do want to say something on the, so maybe the time has come that we need to look at classification. If we are thinking of setting up an intelligence, some agency, or even going further down the road in data sharing, that we need to address the issue of secrecy and classification of documents and necessity in that regard. So maybe that is also, a window of opportunity in a sense, but also a necessity to look at that. Thank you.
Absolutely, to develop joint parameters.